In this video, I want to continue sharing some tips with you young lawyers out there on how you can become a better medical malpractice trial lawyer. Today's topic is getting evidence admitted in court. My name is Frank Spector. I'm a medical malpractice lawyer in Maryland and DC. I've been doing this for over 33 years. During that time, I've had the privilege of representing thousands of people, helping them getting the justice and compensation that they deserve. I was also an adjunct professor at my law school. I'm sharing the tips I shared with my students with you. It's really important that you know how to get evidence admitted, because if you don't know how to get evidence admitted into court, you're likely going to lose. Especially, a lot of lawyers don't take the time to think about the steps on how they're going to get a piece of evidence admitted. They just think, I don't know, automatically it's just going to come in or the other side's going to agree to everything. Now, the truth is that many times lawyers can agree on evidence and we don't have to worry about those rules, but that's not always the case. So you need to be prepared on how you're going to get every piece of evidence in a medical malpractice trial. Let me give you a common example. The medical records. The medical records need to be admitted into evidence. Medical records are just not self-admissible. You can't just walk in with a beautiful binder that has all the color codes that you want with a nice cover on it and think that's just going to be admissible in and of itself. You need to understand the steps on how to do that. Now, many times the other side will agree that the medical records are admissible, but not always. So you have to learn the steps to do that. And what you have to understand is that you're going to have to bring in the custodian of the medical records from the hospital. You're going to have to send a subpoena well in advance of trial. And you're going to have that person come in and put them on the stand and show them the medical records and ask them the pertinent questions. These are business records exception to the hearsay rule. Those of you who remember the hearsay rule will understand that an out-of-court statement is not admissible unless there is a certain foundation that's laid. So you need to establish with this custodian of records that these are the medical records. These are the records that are kept in the ordinary course of business of the hospital. They're true and accurate records. And if you don't do that and the other side's taking a hard line, you're not going to be able to get those medical records into evidence. But a lot of lawyers don't take the time to think about how they're going to do that. So take the time to think about every piece of evidence and how you're going to get that piece of evidence admitted in court. I'm going to be doing more videos about evidence with other examples so that you have all that information available to you, again, so that you can become a better medical malpractice lawyer. Thanks for watching. I look forward to seeing you again soon.